We now move on. There's a private member's bill, Companies Amendment Bill, as Deputy Donnelly. Company Amendments Bill, first stage. Could I call on Deputy Donnelly to move for leave to introduce the bill? You may have up to 5 minutes to introduce your bill.
Now?
Now, yeah.
I didn't know that.
New standing order changes. Yeah.
Okay.
You can just outline,
Right, thank you, Ken Corley. The bill seeks to improve the examinership process. And it seeks to build on some good work that I think the Minister has already done in moving the examinership process from the High Court to the Circuit Court. I'm working, Cian Corla, with senior counsel on putting the bill together and with a solicitor called Barry Lyons, who has handled over half of the examinerships that have taken place in Ireland over the last 12 years. The problem with the examinership process right now for a lot of companies that are viable is the examinership process is too expensive. It can cost north of €150,000. Creditors can act in a mischievous manner so they can keep the company in court and essentially muscle them out of the examinership process. In the process, there are a lot of foreign banks looking to get out of the country who have security on something called on-demand loans. So what's happening to a lot of viable small and medium companies around the country is an examiner is appointed, an independent accountant is appointed, the courts approve the examinership process, the jobs can be saved, the company can be saved, but the bank insists on security against the asset. It activates the on-demand nature of the asset, and in doing so forces the viable company to have to go out to borrow far more money than it can in these capital-constrained times. So the bill addresses all of these issues. What the bill does is it brings the examiner, the directors of the company and the creditors together outside of the courts, so you don't incur all of those costs. It allows for a quasi-judicial process where there is recourse to the courts at any stage for any party. We have put a clause into the legislation which means that the court ultimately must give approval, must rubber stamp it, but instead of all of the parties having to go to court armed with their various counsel and therefore costing everybody a lot of money, the method is much more like the new insolvency service where the papers, if non-contested, go to the courts, the judge makes sure everything is in order and then gives judicial approval and judicial authority to the examinership process. It is my belief that if this bill can be taken on and brought into law sometime this year, there are many, many small and medium enterprises across the country that can be saved that otherwise will not be saved. I will not be presenting the bill as a fait accompli. I will be accepting absolutely that it will need to be improved through the legislative process. Obviously, as a non-cabinet member, I don't have access to the Attorney General's office. I don't have access to the sort of policy weight that the cabinet would have. So the bill will be presented here on Tuesday very much as a bill for second stage, that I would very much welcome the government's expertise, the civil servants' expertise in getting it right, in ensuring that it is constitutional, in ensuring that it does not unfairly prejudice various parties involved. The people who have put this bill together with me have, I believe, more expertise in this area than anyone in the country. We've worked very hard in it. We've had some very generous input from the Minister. I don't know whether or not he will accept the bill, but certainly it is our belief that if this bill is accepted through second stage, if it can be amended as necessary to guard against constitutionality, to bring in whatever other good ideas members of the House may have, there are many, many jobs and many, many fantastic companies who will be able to successfully avail of the examinership process. They're not able to do that right now, and I welcome and voted for what the Minister did in December, which was to move it from the High Court to the Circuit Court. This is the next step. This is the step that says, look, we can reduce the cost of examinership from, let's say, €150,000 to €20,000. We can reduce the funding, the refinancing requirements post-examinership. I'm going to be sending deputies a memorandum of, an explanatory memo, a Q&A, the draft bill in the next 48 hours or so. And we have a worked example which shows, based on what's currently going on out there, Under the current legislation, the company would have to refinance, I think, about €400,000 from memory. Under the new legislation, it would have to find, I think, about €70,000. So, as I say, Ceann Comhairle, I'm not presenting this as a perfectly finished piece of legislation. Obviously, I don't have the resources to do that, but it is being presented in a spirit of cooperation. Obviously, things would have to be changed, and I do hope that the Minister and the Government will have a think about whether or not this can pass second stage and whether over this year we can work to tick the boxes, make it work, and I believe save an awful lot of jobs in this country over the next few years. Thank you.
Thank you. Is the bill being opposed? No. I declare the motion for leave to introduce agreed. Since this is a private member's bill, I'd ask the Deputy to move that the second stage be taken in.
I so move.
Is that agreed? Agreed.